On the whole, having resolved all the issues against the appellants, it is my view that there is no merit in this appeal, and it is hereby dismissed. The judgment of the court below, delivered on the 6th of September 2023, affirming the election of the second respondent as the duly elected President of the Federal Republic of Nigeria, is hereby affirmed. I shall make no order as to costs. My learned brother on my right will deliver his judgment.
Well, my lords, learned senior counsel and all other counsel, this time around it will not be a 12-hour judgment. So, my Lord, Honorable Justice Okoro has said it all, but we must agree. So, having had a preview of the judgment of my learned brother, John Ian Okoro, JSC, availed me with a copy of the said judgment just delivered in SC/CV/935/2023, Atiku Abubakar and the Independent National Electoral Commission and others. I completely agree with the critical analysis of both the oral and documentary evidence presented before us in this appeal. Therefore, I agree with my learned brother that the motion of the appellants filed on the 6th of October 2023 for leave to the appellants to adduce fresh or additional evidence is devoid of any merit. I also dismiss the same. On the main appeal, my learned brother resolved all the issues, the 7 issues against the appellant. I therefore agree with him that the issues in the main appeal are devoid of merit, and the appeal is accordingly dismissed. And I also did not make any order as to cost, but affirmed the judgment of the lower court, declaring the second respondent, Bola Ahmed Tinubu, as the duly elected President of the Federal Republic of Nigeria in the election of the 25th of February 2023. Thank you.
My learned brother to my immediate left will deliver his judgment.
The lead judgment just delivered by my learned brother Okoro JSC has comprehensively presented all the points I made and the views I expressed at the conference of the Honorable Justices of this panel over the appeal. He has very proficiently presented all the views which I express in respect of all the issues in both the motion for leave to adduce or produce fresh or additional evidence, as well as the first respondent's motion to strike out some grounds, and the main appeal itself. But I would like to say that the point raised by the learned senior counsel for the appellant, Chief Chris Uche, particularly in respect of the application of Section 285(6) of the Constitution, appears to me interesting. taken along with the relevant provisions of the Constitution, as well as the Electoral Act 2022, is with respect to Chief Uche Ezean spacious. As demonstrated in the plea judgment, the provisions of Section 285(6), even if the Court of Appeal is not specifically mentioned in that section, the provisions of Section 285(6) is applicable and apply to all proceedings in respect of all petitions, whether before tribunals or the Court of Appeal sitting as a court of first instance trying a petition named presidential election petition, for which it was conferred or vested with the original exclusive jurisdiction to try and entertain under Section 239(1)(a) of the Constitution. So I completely agree. This is an interesting point, like I said, because this is the first time it is coming up, and it is good that this court will make a firm pronouncement in order to avoid further or future arguments in respect of this particular issue. In addition, the issue of a candidate scoring 1/4 of votes in the FCT has also been settled by this court before now. And it is in line with that decision and position that the lead judgment had affirmed that the FCT is not elevated to a higher pedestal than any of the states of the Federation. It is, for the purposes of the presidential election, one of the states for which a candidate is required to obtain at least 1/4 of the votes in 2/3 of each of the states. So I totally agree with the lead judgment that this court lacks the requisite jurisdiction to entertain the application for leave to produce fresh or additional evidence, and that this appeal is also lacking in merit and deserves to be dismissed. I also dismiss the appeal, and that will be my judgment in this appeal. I abide by the consequential orders made in the lead judgment on cost to be borne by the parties for the prosecution of this appeal.
My little brother, Salawa, will deliver his judgment.
My learned brother, the Honorable Justice Okoro Jesse, has accorded me the opportunity of a preview of the judgment that he has just delivered. I must say that I have read that judgment, and I'm very much content and appreciative of the far-reaching, erudite reasoning and conclusion that have so far been reached in the lead judgment. I concur with the highest sense of responsibility with the reasoning and conclusion reached therein. With particular regard to the interlocutory application, thereby urging upon this court grant leave to the appellants to procure and transmit and adduce fresh or additional evidence at this crucial point in time of the appeal. I concur most assiduously with the conclusion that has been reached in the judgment of my learned brother that such an application is grossly unmeritorious, thus ought to be dismissed, and same is accordingly hereby dismissed by me. And as for the substantive appeal itself, which has been predicated upon a total of 7 issues, I agree entirely with the reasoning eruditely expressed by my learned brother that each of the 7 issues that have been canvassed and argued by the appellant are grossly unmeritorious, thus ought to be resolved against them. Without much ado, I hereby accordingly dismiss the appeal for being grossly unmeritorious. As usual, it is not the time for us to read elaborative judgments. Just like my learned brother said, 12 hours. We're not going to do that because learned counsel representing the respective parties in this appeal will have every opportunity to be served with the complete judgments of each and every justice of this panel in due course. Because constitutionally, we have a total of 7 days within which judgments must be served on the respective learned counsel that appeal. Thank you very much.
My Lord Jaro, read your judgment.
Thank you. Well, I have had the privilege of reading before now the lead judgment delivered by my learned brother, John Iam Okoro, JSC. His Lordship has ably considered and resolved all the issues in contention in the appeal, as well as the application. I agree with the reasoning and conclusion reached therein to the effect that the appeal is bereft of merit and deserves a dismissal. The application, too, is not meritorious. Accordingly, I dismiss the application and the appeal. That is my position.
My Lord Abubakar.
I thank my Lord the Presiding Justice, Honorable Justice John Iam Okoro, for granting me the privilege to read in draft the lucid and illuminating leading judgment just delivered in this appeal. I start with the application. The application seeking to adduce additional evidence or fresh evidence, I also find it lacking in merit. The application is frivolous and vexatious. It deserves to be dismissed, and it is hereby dismissed. Now, coming to the substantive appeal, I find no merit in the substantive appeal. It is also dismissed. On the whole, therefore, the appeal is dismissed and the judgment of the lower court is affirmed. parties in this appeal shall bear their respective costs.
Yes, Iroko. Agim, JSC.
With the kind permission of the learned presiding justice, let me also express my view. I had a preview of the judgment delivered by my learned brother, Lord Justice John Okoro, JSCFR. I completely agree with the reasoning, conclusions, decisions, and others therein. And I must remark that it is bristling with commendable erudition. Let me, however, say maybe one or two things, since we will have opportunity, you will have opportunity to have our views, that the deposition is, for this additional reason, inadmissible. So if a document is inadmissible, you cannot ask that you should be allowed to bring it in as fresh evidence. A reading of the deposition exposes that it is not authenticated by the seal of the authority before whom it was issued. A deposition from another country to be used in Nigeria should prima facie bear features of authentication, such as the official seal of the court where it is sworn, if it is the court, or if it is before a notary public, his seal or signature, or if sworn before a person legally authorized to take the seal, or if sworn in the Nigerian Embassy, High Commission, or Consulate in that country, the signature of the officer authorized to do so, and the seal of the Embassy, High Commission, or Consulate. Such authentication is an assurance of the origin and authenticity of the foreign disposition. In our present case, the certified shorthand reporter, before whom the deposition was made, did not authenticate the deposition with her seal. She merely signed her certificate of reporter, bearing her name and number, page 126 of Exhibit C. Being a deposition from another country, it cannot be used in Nigeria without authentication. The authentication of the oath administration is mandatory. I have wondered why the deposition said to be made pursuant to the 3rd October 2023 order of the United States District Court for the Northern District of Illinois in case number 23 CV 05099 for use in a foreign country was not made before the court in the said proceedings. And if made elsewhere in the law office of the first appellant's attorney, why was it not filed in the above-mentioned court? Because of the peculiar circumstances of this case, and adopted as a deposition ordered to be made by the court, so that it can form part of the record of that court to enable the court issue it as part of its record, also authenticate it with the seal of the court and the signature of the relevant officer of the court. Page 1 of the deposition is headed in the United States District Court for the Northern District of Illinois in reapplication of Atiku for an order directing discovery from Chicago State University pursuant to 28 U.S.C. 1782 number 28 CV 05099. This gives the impression it is a process of the district court, or that the deposition, though made outside the precincts of that court in a private law office, is part of the proceedings in case number 23 CV 05099. If it is indeed a process of the said district court, or forms part of the proceedings in case number 23 CV 05099 before it, then it ought to have been authenticated by the official seal of the court and the signature of the relevant officer certifying it as a true copy of the part of the record of the court in case number 23 CV 05099 Without such authentication, a deposition cannot be used in the Nigerian court as part of the proceedings or in the said U.S. District Court. And I've continued to wonder why the college, why the appellant did not use the advantage of the order of the district court that the college produced documents and a deposition concerning those certificates. Why they didn't use that advantage to secure a letter from the college under its letterhead, seal, and signature, disclaiming the certificate presented by the second respondent to INEC as not one issued by the college. That was not done. Instead, they resorted to this deposition, which has no features of authentication, thereby rendering it spurious and inadmissible. I agree with the able manner the lead judgment has dealt with it. I agree totally with all the reasons given in that decision as to why such an application should be refused. And it emphasizes one point. It was obvious to all, including those who brought it, that it was going nowhere. Then the question is, why was it brought? And I agree with my Lord when he described it as a vexatious process. I dismiss the application too. I go to the appeal. I agree completely with the lead judgment. I cannot say it better than that. It was a real brilliant expose on all the issues raised. Let me also join my Lord Garba to talk about a question of Abuja and 1/4 of the votes there, that the candidate must win. The view that the provision of the Constitution should be applied in such a way that the votes in Abuja must be won. 1/4 of the votes must be won by a candidate before he can secure victory in the election. To me, violates a fundamental principle of constitutional interpretation, that it must be interpreted to protect the spirit of the Constitution. And if you look at our Constitution, it promotes egalitarianism, equality. So it must be applied in such a way as to protect the equality of the votes in all the entities, and not otherwise. I will expand on that in my judgment. So I do not agree with the interpretation placed upon it. Attractive as it may be, but we must bear in mind that there's no jurisdiction in the world where a constitution is read in isolated patches and given meaning that should have, very narrow meaning that should appeal to certain sentiments. No, you apply it as a whole, reading it completely together, so that you rely on one part to get a meaning in another part, that the words can truly support the wordings used in that provision. That is how to read a constitution. Remembering that it is dealing with a dynamic system, a human society. For these reasons, I also dismiss the appeal. I also agree that the parties should bear their costs. Thank you very much.